Welcome to the game of Case, Riley versus California version, where you are the petitioner trying to show the unconstitutionality of warrantless cell phone searches in light of the Fourth Amendment. Let's spin to get started. The career you have chosen is a gang member. Uh-oh, you got pulled over for driving with expired license plate stickers. They found out that your license was suspended too. The police took your vehicle and searched it, and then they found 2 guns under the hood. You're in trouble. After the police found the guns under the hood of your car, they searched your cell phone and discovered that you're a part of a gang. They charged you with 3 different gang-related crimes, including attempted murder. Now you will go to jail and wait for a trial. You know that the only way for you not to get convicted of the crimes of which you've been accused is to get rid of or suppress the evidence that the police found on your cell phone. You can suppress that evidence on the grounds that the search was unreasonable and violated your Fourth Amendment rights to be free from unreasonable searches and seizures. Since the judge denied your motion to suppress the evidence, you were convicted and sentenced to 15 years to life in prison. This conviction won you your starter home, a jail cell. You decide to appeal your case to the 11th Circuit Court of Appeals. There, they decide that their conviction was legal and you remain sentenced. Spin to win. Get a 5 to win the case. Uh-oh, you lost the case. But since you didn't like that conviction, you decided to appeal again, this time to the California Supreme Court. They decided not to take your case because they had already decided on a similar case, and the answer was no. Spin to win. Get a 3 to win your case. Since you still didn't believe that your conviction because of evidence on your cell phone was fair, you decided to appeal to the United States Supreme Court. Payday, the Supreme Court took your case and you got a great lawyer. Jeffrey Fisher is a professor at Stanford who has argued over 32 cases in the Supreme Court. I think you've got a good chance. Your lawyer's arguments were very well received. His main point was that the types of information on cell phones and how sensitive they are and how much information there is makes it very different from the small amounts of information that might be near a person at the time of their arrest, such as a wallet. Payday, you scored an amicus brief from the Brennan Center for Justice. They argued that you need a neutral third-party judge to determine if the need for evidence outweighs the invasion of privacy. The case for California was argued by Edward Dumont. He said that he doesn't think that the expansion of volume increases the invasion of privacy. He said a lot of times that 5 photos in a wallet are no different than 10,000 photos that might be on a phone. Mr. Dumont took the risky path while he was arguing. He and Justice Kagan got into a bit of a heated discussion about whether or not one of the cases that they were talking about was a marginal case. They never came to a clear understanding of whether it was a marginal case or a very common one, and I believe that that did not help him win the case at all. There is also an amicus brief submitted for California by the Association of State Criminal Investigative Agencies. They argued that the police need easier access to the cell phones, and making it so that they have to get a warrant would be detrimental to their investigations. The first case that set precedent against you was Chimmel versus California. In this case, a standard was set that unless it affects officer safety or the preservation of evidence, you have to get a warrant for everything you search. Another case that set precedent against you was U.S. versus Robinson. This case determined that It's okay for police to search things that are in your pocket at the time of an arrest. So it seemed logical that if a cell phone was in your pocket when you were arrested, that would be okay too. You won the case. It's very surprising that since the case broke precedent, it was a unanimous 9-0 decision. In the judge's opinion, they wrote that the reason they decided the way they did was because it's such a significant invasion of privacy. They also said that since it's so easy for the government to search a phone and so much of an impact on the person whose phone was searched, it would give too much power to the government. Justice Alito agreed with the court, but for a different reason. He wrote a concurring opinion saying that he didn't like that the cell phone searches didn't fall into the warrant exception, which was officer safety or the preservation of evidence. However, since there was such big privacy issues at stake, the way that the court decided would be best. Riley versus California had a lot of long-term investment impacts on our country's privacy issues. If the court had decided the other way and the warrantless searches were legal, if you got pulled over for a speeding ticket, the police could search through all of your photos. So roll a 10 and score cell phone privacy. And that's the case of Riley versus California.